immigrationquestion.com, your go-to resource for U.S. immigration insights. We provide clear immigration news and information. Our platform provides a network of licensed attorneys who can answer your questions and guide you through the process. From visas to green cards, asylums to citizenships, immigrationquestion.com helps you to network with immigration attorneys so that you can move forward with confidence. Sign up today or download the app. Free registration, limited time offer. Stay tuned. We go live in 30 seconds.
Hello, everyone, and welcome to the special edition webinar hosted by immigrationquestion.com, a networking platform and meeting ground where immigrants, families, advocates, and licensed immigration attorneys come together to understand U.S. immigration policies and procedures better. My name is GB Satusa, and I will be your host for today's important discussion, how to reopen or appeal your immigration case after a denial. Receiving a denial in an immigration case can be stressful and discouraging. However, a denial does not always mean the end of the road. In certain situations, applicants may have legal options to challenge the decision, submit new evidence, or request a review of the case. Understanding when a motion or appeal is appropriate and how these legal tools work can help individuals seeking to protect their immigration status or continue pursuing relief. To help us break this down, we are honored to be joined by Isadora Velazquez, Esquire, an experienced immigration attorney who assists individuals and families navigating complex immigration procedures, including post-denial motions, appeals, and removal defense strategies. Attorney Velazquez, thank you for joining us today. We're thrilled to have you for this important discussion.
It's my pleasure. Happy to be here.
Now, before we begin, a quick reminder to our audience, immigrationquestion.com is a public educational and networking platform. The information shared today is for general informational purposes only and does not constitute individualized legal advice. If you're joining us on Facebook, YouTube, LinkedIn, or any other platform, welcome. Please subscribe and share this session with anyone who may benefit from understanding what options may be available after an immigration case denial. Now, let's dive right in. Attorney Velazquez, what options are available to someone whose immigration case has been denied?
Well, the most common option, of course, is the appeal. We hear about the appeal during the court proceedings. The judge will let us know how much time we need. And that's important because these regulations are changing as of March 9th, actually, as of today. In the Federal Register, they'll be reducing the amount of time we have to appeal and when responses are due. So the most common one is the appeal, but it's not the only one. We also have motions to reopen and motions to reconsider, which we'll be discussing further today, and are very important because they have longer time periods in which we can choose to bring forward our case. So they're very helpful to people who may have long-standing deportation orders, cases that we may think are old and maybe there's nothing we can do. They can be brought back to life based on these proceedings. So very two useful cases or options to bring a case back to life.
Yeah. Now, what is the difference between a motion to reopen and a motion to reconsider? And when is each appropriate?
A motion to reopen should be based on something new, whether it's mainly because it's new evidence that was not available back then. It could also be based on changes in law. That's why something new is what triggers a motion to reopen. And that's why we also see a motion to reopen when the Supreme Court issues a decision that maybe changes the way things were processed when a case was adjudicated back then. Meanwhile, a motion to reconsider tends to be because of a mistake. Maybe you read something in the decision that you realize the judge misinterpreted. It could be the law, or it could be maybe the facts. Maybe they thought somebody was a child when they're a parent. Something should be reconsidered because it was misinterpreted. So there's a difference between evidence and changes. Those are something new, and a mistake, something that should be reconsidered. That's why between reopening, new evidence, something new, and mistakes, reconsidering.
Now, and when is each appropriate?
They would be appropriate based on what you're reading the decision. When you're reading the decision, you see that it was based on a decision that misinterpreted the law or misinterpreted the facts, then a motion to reconsider would be the right one to choose. A motion to reopen would be on something new, a new evidence. So some new circumstances in your life, you're married, you have children, or something new is discovered, or a new change in law. The Supreme Court decides that a new regulation should come into play, a new way to moving forward in the cases, or the way things were done previously was wrong. So because something new is determined, that's when you choose to use these type of motions. Also, time may come into play. If you're using an appeal, you have 30 days to decide. But if you maybe are waiting too long, the motion to reopen, for example, would be used when the new item happens. You get married, you would file a motion to reopen because you have this new evidence. It should be filed close to when the new evidence happens, because once again, the newness is what's giving you the option to file this remedy. So if you wait too long, you choose the ability to move forward with it. Motions to reopen should be filed no more than 90 days from the day of the event, whether it's a decision or when the new evidence occurs, the marriage, the change in law. So keep that in mind. If you wait too long, you may lose it.
All right. Now, Attorney, what types of new evidence or legal arguments are required to reopen a case successfully?
The most common new evidence tends to be personal circumstances. We live here for a long time and things happen in our life. For example, a marriage tends to be a personal circumstance that gives us new legal remedies that were not available when we first had our case presented and are now available. Children that come and maybe are in asylum proceedings with their parents, live their adulthood life here, and now are married and now have a new legal remedy based on their marriage to their spouse. Same thing with adults who have children here and their adult children now turn 21. That is new evidence that was not available when the case went forward, and it's a change in your life and circumstances. You didn't have your child of that age. Maybe you didn't even have a child. That's another change in your life circumstances. So those step to be the new evidence. Now, in terms of new law, that tends to be executive orders. DACA is a great example of new law that came forward and maybe gave the opportunity for many individuals to now be no longer subject to removal because they came as children and now they had a new remedy that would protect them as dreamers. Similarly, waivers that come up based on regulation, not a change in law. The immigration laws have not changed in almost 40 years. They're very old and very antiquated. But regulations published in the Federal Register, they do change and new come up, and they give us new waivers and new ways to apply for certain benefits. Those changes in law allow us to file for a motion to reopen saying we're now eligible for this new remedy, new benefit, and because this is now available, we would like a motion to reopen. And lastly, court decisions. Court decisions allow us to file for motions to reopen because they also create a new law, or at least the argument of new law. The best and most recent one was when the Supreme Court decided that notices sending you to court should have a date and a time. Many cases, old cases, were able to be reopened because they didn't have a date and a time, but they were able to be reopened within a specific time from the date that decision came forward. Because like I said before, you have 30 to 90 days from the day of the incident to file your motion to reopen. So those tend to be the evidence you use, life circumstances or decisions and changes in the law.
Now, in cases decided by USCIS versus those decided in immigration court, how does the appeal process differ?
One is administrative. So USCIS is administrative and you send it to administrative appeals. It's AAO, and they'll tell you the specific form that you have to complete, and you have to mail it administratively. You actually have to file very specific instructions. And if you make the mistake of sending it to the wrong place, you face similar consequences as if you had done it to court, meaning that if it's too late, it won't be processed. Very strict appeal administrative process. That's the big word, administrative. So it's not done before a judge, which is the big difference when it's in the court process. Any court proceeding will be appealed to the Board of Immigration Appeals. The form is completely different. The address is always the same. It will be in Virginia. It's a 3-panel judge, but not necessarily 3 judges will hear it. Most likely 1 judge will hear it. There's a severe backlog right now of over 200,000 cases pending at the Board of Immigration Appeals. A judge tends to read it, and if the judge finds it significant enough, then I'd suggest it to move it forward to the 3-judge panel. Most of the cases sadly get either dismissed, meaning disregarded, and the decision is upheld, or reviewed, but most of them sadly will be dismissed. So now there's new changes, as I mentioned, that come in now in March, forcing this dismissal to come forward sooner in 15 days instead of the years that this process can take. So that will be a big change in the court proceedings now, with these sending the cases to the Board of Immigration Appeals and having 1 judge issue a decision in 15 days in how we submit our briefs. That's also a significant change, a difference between the administrative process and the court proceedings. You have a briefing schedule in which you can write your briefs. In the administrative process, you submit it all at once. Meanwhile, in the court proceedings, you can have time to develop it. That time is being reduced significantly now with the new regulations. Both parties, meaning the government and the respondent, meaning the person going through the trial, will have to submit the briefs together. So it's going to be very interesting to see how this appeal process goes forward and if it even survives with these new laws.
Truly, truly. Now, Attorney, what role does the Board of Immigration Appeals play in reviewing immigration decisions, and what should applicants expect during that process?
A lot of silence, because the way it works, like I mentioned before, is that right now with the backlog, the 200,000 plus cases will continue being processed in the same way. And the same way means that typically is 1 judge who reviews them. But when there's such a significant backlog and not enough judges, this is going to take a while. So 1 judge will review it and then determine if it's worth having the panel look at it. And that's why most cases will be dismissed, but it will take years for that dismissal to happen. During that time, I encourage anyone who has an appeal process to submit a stay with that appeal process, because understand that any decision that might be appealed right now, particularly with this administration, might be considered a final decision despite the appeal process. And we have seen how some removal orders have been executed despite being on appeal. So I encourage anyone who is submitting an appeal to the Board of Immigration Appeals to tie that with a stay of removal so that the order is not executed and that you're protected. So it's going to be, for old cases that have been submitted, a long process in which the judge will eventually get to it, and hopefully you'll be lucky and they will see the light and rule in your favor. But for new cases, it will be a rather quick process in which in 10 days you have to appeal. In 15 days, the judge is supposed to tell you if they're going forward or not. And we'll see how that happens, because it's starting literally as we speak right now.
Now, are there risks to filing an appeal or motion, particularly for individuals who may already be out of status or in removal proceedings?
The risk is what I mentioned before. Technically, I do encourage anyone who has an order to move forward and appeal and file the motion, because if you don't do anything, the order definitely becomes final. However, appealing or filing the motion does not really protect you from, it's not a guaranteed protection from removal. So appealing or submitting the motion right now is simply not enough. So the risk should be just assuming that filing this may be a protection from any removal or the execution of the removal order. It's not. So my advice is you must add to the appeal or to the motion to reopen a stay of deportation. It's very important. Now it's required for, it can be a stay to the Board of Immigration Appeals. The only motion that has a stay of deportation already included is when you have a motion to reopen a deportation in absentia. And those are for individuals who gave their correct address and for some reason never received a notice sending them to court. That's a deportation in absentia because that was a mistake from the court. or they were on their way to court and something happened that was out of their hands. There was an accident, something happened that they can explain why they couldn't show up on time, and the deportation in absentia happened. Because they can justify it and there's a valid reason, those are the only motions that don't require a stay of deportation, that it's automatic. All other motions, an appeal or a motion to reopen, reconsider, should be accompanied by a stay of deportation, because otherwise the order could be executed. So you must protect yourself no matter what.
Now, looking ahead, what practical steps should applicants take immediately after receiving a denial to explore their legal options?
Well, it may sound cliche because I'm an immigration lawyer, but my advice to everyone, you must consult with an attorney if you don't have one already. Of course, I encourage anyone who is in any court proceedings or in any proceedings with immigration to have a lawyer guiding you through the process. Ask the attorney what happened, the attorney who's guiding you, what went wrong, how can we look at this, how can we appeal, what happened with the decision that we can dissect so that it can be appealed. And if it's something that the attorney considers cannot be appealed, okay, any mistakes in the decision, what can we analyze together? Maybe the judge missed something about my children, or any other evidence that we didn't know, that we didn't produce. You need to start analyzing the case right away, because the appeal rules will be changing immediately. For the motion to reopen and the motion to reconsider, you may have more time. So that's why my second advice is, don't give up. You must have near you always, before, I've been practicing for a while, so I used to say have a drawer or a box and put your documents there. Now I would say have a folder in which you always save your immigration record and what happens in your life. Before, at the beginning of this webinar, we were discussing what evidence could happen in your life that would lead to a new immigration remedy. We were talking about having kids, getting married, the life that we live. If you document this correctly and something were to happen in your case, you can take immediate action to protect yourself. What you're seeing lately is a quick uptake in detention and motion orders that have to be executed right away that can maybe be stopped by a quick motion right now. So my advice is just be ready and be cautious, but not to give up right away. There's definitely ways to revert and reanalyze whatever may have happened if there's a negative decision against you.
Thank you so much, Attorney Velazquez. Truly an insightful session so far. Those are very valuable insights. Now, for everyone watching, this discussion about reopening or appealing an immigration case is not meant to create false hope, but to provide clarity about the legal options available after a denial. In many cases, the key is understanding deadlines, identifying whether new evidence is available, and evaluating whether the original decision involved a legal or procedural issue. If this is your first time joining us, welcome. ImmigrationQuestion.com is a networking platform where users can ask immigration-related questions at no cost and engage with participating attorneys. We're also proud to share that ImmigrationQuestion.com is BBB accredited and ISO certified, reflecting our commitment to transparency, accountability, community education, and security. Now, Attorney Velazquez, based on your experience handling post-denial cases, how does ImmigrationQuestion.com help immigrants and immigration attorneys such as yourself?
It helps a lot because people come with real questions. When my clients come after watching one of your webinars, they come with knowledgeable questions, understanding the process and understanding it much better than just simply saying, I need an immigration lawyer. So it's very helpful as an immigration attorney when I have a client who knows what they're seeking because they already saw one of your webinars and understands the process a little bit better. So I appreciate it.
Thank you so much. Thank you so much, Attorney. Now, before we move into our live Q&A, let's tackle this very important question. What is one common misconception people have after receiving an immigration denial that you believe applicants should clarify?
That they have all the time in the world, that there's no hurry, that I can just deal with this later. I have a really big issue right now with people that have decisions that could have been reverted, could have been addressed, but it's now too late. Motion to reopen should be filed no more than 90 days after the the event occurs, typically the decision. So if your life event happens and then years later you want to say, oh, I would like to file a motion to reopen because I am married, we're about to celebrate my 25th anniversary, it's very difficult to convince a judge that this is a new life event when you've been married for quite some time, or when your child is now 52 years old and they're about to petition for you. There's some things that it's not reasonable to make the argument that I didn't know when a lot of time has passed. So don't think you have all the time in the world and just wait when it's really necessary to take action. Take action when the option's there before you. Also, you get one shot at a motion to reopen, only one shot. So it needs to be the best motion ever. It is not convenient to file a motion to reopen because you think maybe I have a wishy-washy argument, or maybe that section of the law, maybe it applies to me. If you're not 100% sure, don't do it, because you're going to miss that one shot of maybe having that one section of the law that does apply to you could be considered. If you lose in a motion to reopen, you won't get a second chance to file it again in the future. So do it right.
All right. If you've just joined us, we've been speaking with attorney Isadora Velazquez on how to reopen or appeal your immigration case after a denial. We are now moving into our live Q&A session. This is your opportunity to ask general questions and hear educational insight from a licensed immigration attorney. Please drop those questions in the chat or call us live at 516-703-3483, and we'll take as many as time permits. All right. My application was denied. Please, what options do I have to challenge the decision?
Because you're saying application, I'm assuming it was with USCIS. So you must look at the actual letter, because there's some applications with USCIS that they will not let you appeal. And the actual denial letter will tell you this decision is not appealable. However, if it's one of those applications that is appealable, the denial letter in the back will tell you, you must use this form and send it to this address. That's why it's really important that you read the denial letter, because it will tell you which form to use. And if it doesn't specify the address where to send it, then you must follow the instructions of the form listed. It will also tell you how much time you have, because if you have an online account, the denial letter or the denial of the application, maybe it was received online via email. If so, you have 30 days. If you're old school like I am, maybe you got it via snail mail, then you have 33 days. But all that would be detailed in your denial letter. So read your denial letter. In the last paragraphs, it will let you know if you can appeal, and if so, how you can appeal, what form to use, and where to send it.
All right. How soon after a denial do I need to file for appeal?
It depends on where you are denied. If you are denied by USCIS and they communicate with you online, you have 30 days to file. If you are denied by USCIS and they communicate with you via USPS snail mail, then you have 33 days, and they will tell you both options in the actual letter you receive. If your denial is in court proceedings, if your denial was before today, you should have heard the judge tell you that you had 30 days, and they should have written in the order denying your case the exact date that you had to appeal. So look at your order, and in the bottom, the judge should have written the exact date that you had to appeal. Typically it's 30 days. So that's why it's important to look at it. Some judges may be really nice and give you more. Unlikely, should be 30 days. And I say up until today, because new regulations will force judges to now say 10 days. So it's important that you look at the order. I don't know how many judges will actually follow these regulations. I hope not many, but if they do, you must look at the order. In the bottom, it will say how many days you have to file your appeal if it's in court.
All right. If I discover new evidence after my case is denied, can I use it to reopen it?
Yes, but be ready to explain how did you discover it? Because one of the main elements for a motion to reopen is that you must show that the evidence was not available. Not only that it was not discovered when you went to trial, that it was not available. So if you're going to say, I discovered this evidence after I went to trial, the second question the judge is going to ask you is, why didn't you have it before? How did you discover this? So if it's something that, oh, my parents told me after trial, be aware that the judge might not want to, or they might not be pleased, or they might choose simply not to reopen your case because your parents maybe knew that you were in court proceedings, should have told you about these court proceedings. So you need to explain, go further, explain why was this not available. I don't get along with my parents. They didn't know I was in court proceedings. I just found out because they wrote it in their will, whatever. But make sure you explain why it was not available. It's one of the main requirements. If you can't justify why it was not available, just finding the new evidence is not enough. Simply saying that it's new, not enough. You need to explain why didn't you have it on the day you went to trial. So that's why life events are easy to explain. I didn't have kids. I was not married. But evidence, actual tangible evidence, you need to explain why you didn't have it.
Yeah. Now, recent reports indicate that the Second Circuit has confirmed that children must be under the age of 21 at the time of adjudication in certain cancellation of removal cases. Now, Attorney, court interpretations of eligibility requirements can significantly affect how immigration relief is evaluated and who qualifies. So, when court decisions clarify eligibility requirements in removal defense cases, such as how a child's age is calculated for cancellation of removal relief, how should immigrants and their families interpret these developments?
They should see it as a way to prepare. The reality is, in most cancellation cases, it has long been understood that when it refers to children, it was assumed at least that because most circuits said that they were children, it was minors under the age of 21. So here the Second Circuit is simply reaffirming something that most courts have already agreed to. But it's important that when immigrants hear decisions like this, they try to restructure their cases and see what evidence they have that may justify it. What children do they have in the U.S.? What children do they have outside of the U.S.? If something were to happen, understanding that cancellation of removal is a remedy that is available only if you are in removal proceedings. If I were in removal proceedings, would this be available for me? And if so, how old are my children and how do I prove it? Also, this is a decision that, although it says that it's only children under the age of 21 are eligible as qualifying relatives, it doesn't mean that you cannot use your children over the age of 21 to show how they would still be relevant as to why you have to stay in the U.S. Just know that it follows most of the precedent all over the United States that children under the age of 21 are the ones that are considered. So you can still present them as evidence. It just won't be as persuasive as any children under the age of 21.
All right. Now, you've already touched base on it, but do rulings like this typically affect only specific cases, or can they signal broader legal interpretations that applicants and attorneys should pay close attention to?
Although they're supposed to be limited by circuits and only to that area, the reality is that they spread everywhere. And that's why we all look at the decisions from all circuits, even if they don't apply to specifically where we live. The best place, and that's what we see also, that the government chooses where to appeal certain decisions. We saw it recently when it came to bond proceedings and how specifically it was chosen to go to the Fifth Circuit, knowing that the government would prevail in such a conservative district. So it's important. So when we hear a decision, even if it's negative, from the Second Circuit limiting who are children under ages and what it can be, that we pay attention, even if it doesn't apply to us, so we can make the argument in our district and maybe try to spread the positive argument everywhere, even if a negative argument is made in a place that doesn't apply to us.
Thank you to everyone who joined us for this special edition webinar. And thank you to Attorney Velazquez for sharing your knowledge and practical guidance today. Really valuable insights today.
My pleasure.
You can always visit immigrationquestion.com to ask immigration-related questions, stay informed about policy updates, and register for upcoming live sessions. If you missed any part of today's discussion, the replay will soon be available on Spotify. Just search Borderless Talk by immigrationquestion.com. We look forward to seeing you on Wednesday at our next live session. Until then, stay informed, stay prepared, and stay connected. Bye-bye.